Thank you for joining us today. My name is Lisa Ammon, and I serve as president of the Louisville Forum. We meet on the second Wednesday of every month at Vincenzo's Restaurant. Come on, right there. You're right there. The Louisville Forum is a nonpartisan public issues group founded in 1984. The forum hosts debates and discussions on contemporary and sometimes controversial public policy issues that affect the greater Louisville community. Although we may take up an issue that has national significance, we try to highlight the local perspective. For more information on the Louisville Forum, our programs, or to make reservations, please visit our website at louisvilleforum.org. Today we will explore the topic, Supreme Choice, a legal debate whether the Senate, led by Majority Leader McConnell, should consider President Obama's Supreme Court nominee. The battle over filling the Supreme Court vacancy, created with the death of conservative Justice Antonin Scalia, has reached a fever pitch. Both sides have a variety of reasons for their position. On one side, some contend that Senate Republicans are shirking their duties by considering President Obama's Supreme Court nominee, by not considering President Obama's Supreme Court nominee. On the other side, some argue that their refusal to hold hearings on the nomination allows for the American people to have a say through the 2016 presidential election. At stake is the ideological balance of the Supreme Court. The death of Justice Antonin Scalia was monumental. With Scalia, the court had 4 reliable conservative votes, and in some instances with Justice Anthony Kennedy, the court had a swing vote. Justice Scalia's death happened in the middle of a blockbuster court term with a host of hot-button cases from immigration to reproductive rights to be decided. The stalemate has the potential for the Supreme Court decision to result in a 4-4 tie, which means the decision of the lower courts would stand. Today we're happy to be joined by our panelists. We have Richard Dawahare here, Senator Morgan McGarvey, Professor Russell Weaver, and Andrew Condia, who's a field representative for Senator Mitch McConnell. And now to our first speaker. Richard Dawahare, a native of Whitesburg, Kentucky, moved at age 6 to Lexington in 1961, when his father opened the first Dawahare store outside of the mountains. He has enjoyed a multifaceted career since graduating from Lafayette High School, the University of Tennessee, and the University of Kentucky Law School in 1979. After passing the Kentucky bar in 1979, Richard embarked on a nearly 30-year career as a merchant, first with Macy's, then 26 years with Dawahare's until the chain's closing in the fall of 2008. Richard began his legal career as a sole practitioner focusing on family law, elder care, estate planning, and probate. He regularly works in guardianship court and serves as a guardian ad litem for neglected and abused children in family court. He now practices with Elder Law Lexington, McClellan and Associates, primarily focusing on veterans' benefits. Richard has a lifelong interest, if not a passion, for the pursuit of justice and strengthening our social compact, our country, and the greater public interest. Please welcome Richard Dawahare.
Hello, everybody, and I want to thank you for having me. It's a real honor to be here. Your group and groups like yours are really important to discuss the issues in a civil way, hopefully lead us all to a higher degree of understanding and better society. So I thank you. And I want to say at the outset that, I think we're all on we all have the same goals. I really believe that we all want what makes our country stronger and better, a happier, healthier population. And, we have different we have different ideas about how to get there, and that's what it's all about. Hopefully, in pursuing policies and ideas, we look for facts, we look at reality, we use reason, we use heart. It's all important. And the tendency, and I know I'm top of the list on this, is to dig our heels in and this is the right way. But in reality, if we're really looking for the greater good, we want to look at all ideas and look at reality, look at the facts. Now, applied to this topic, which I believe is actually misstated. They actually stated the outlier position, should the Senate confirm or consider and confirm this nominee, Merrick Garland. The precedence in the history has been that in the president's last term, the Senate has always confirmed the choice, the nominee. That's the position. So the question should have been, should the Senate-led, McConnell-led Senate ignore history, ignore the Constitution, and refuse to even consider this fine nominee? But in looking at the issue, I want to take the same approach as I mentioned. Let's look at reality, let's look at facts, let's look at the whole greater picture and come to the right conclusion. Of course, they should be not only considering but confirming Merrick Garland. First, the Constitution calls for it. The President nominates, the Senate advises and consents, which is confirming that choice. Now, sure, the duty is on the President, in this case President Obama, to put forth a qualified nominee for the court, as all presidents have done before. Now, the standard for a good nominee is one that has a strong track record of sound judicial legal reasoning and analysis, knows the law, fairly applies that law to the facts at hand to do the greatest amount of justice with the facts and the law. There is no ideological standard, absolutely none. The best justices actually could have been appointed by a Republican president in the past or a Democratic president. Some decisions are going to rule on what people would consider as a conservative based opinion, or some a liberal. But the fact is, the good justices are always looking at the law, applying it to the facts at hand, with a keen understanding of the world in which they live, and they make a decision. It's not ideological, it is judicial, and is based on sound reasoning and justice. So, with that in mind, we have put forth, President Obama has put forth a very well-qualified nominee, Merrick Garland. So much so, in fact, that Orrin Hatch, who now agrees with Senator McConnell they should not consider him, well, he didn't have any problem with him just a week before, a week or so before President Obama nominated him. In fact, he said this. He said, the president told me several times he's going to name a moderate to fill the court vacancy, but I don't believe him. Obama could easily name Merrick Garland, who is a fine man. He probably won't do that because this appointment is about the election. So I'm pretty sure he'll name someone the liberal Democratic base wants. No, he didn't. Orrin Hatch didn't have a problem with Merrick Garland in 2010. In 2010, when they were discussing Elena Kagan's seat, Merrick Garland had this to say. He said, Orrin Hatch said that he had known Garland for years. He added if it nominated, he would be a consensus nominee, and that there was no question he would be confirmed. And he didn't have a problem with him in 1995 when Merrick Garland was up for the D.C. Court of Appeals where he sits now. In 1995, Orrin Hatch said Merrick Garland is highly qualified to sit on the D.C. Circuit. His intelligence and his scholarship cannot be questioned. His legal experience is equally impressive. Accordingly, I believe Mr. Garland is a fine nominee. I know him personally. I know of his integrity. I know of his legal ability. I know of his honesty. I know of his acumen. And he belongs on the court. That's the truth. That's the reality. And other fine Republicans spoke in favor of Merrick Garland. What's changed? I don't know. In all justice and fairness, he should be considered and confirmed. The Constitution calls for it. Our nation's precedence calls for it. It's proven that way. And there's no good reason not to. There is a very practical reason. Right now, the court, if it splits 4-4, the lower court's decision will be the law until some future date that the court, again, has 9 people and they can decide definitively on whatever issue that is. Justice delayed is justice denied, and that's no good. But that's not the key reason. The key reason is history, tradition, and Constitution calls for it. One final thing. If McConnell and the Republicans have their way, That will destroy the integrity of our judiciary, will further weaken our nation, and it is not the way to go. The court is here to do justice, and our leaders should be leading. You know, we have, a divisive nation. You see what's happened in rhetoric, what's happening in the parties. This is a real opportunity for Senator McConnell and Republicans and the Democrats to come together and to show that our institutions and our values and our principles, world leading, can withstand the conflict, and that they can come together for the greater good. And it's an obvious thing to do. It's a right thing to do. They selected a good justice who will decide on the law and the facts and make good decisions, as he's done for many decades. And it cost him nothing to do the right thing. It can only build unity and consensus in our world today. The people have spoken. They elected President Obama twice in electoral landslides. It's early in his last year. The history in every situation before this, they have nominated, they have confirmed that nomination, and they should do so now. And I thank you all again for coming and allowing me to speak. I look forward to hearing my colleagues, and wish everybody well. Thank you.
All right, thank you. And next we have Professor Russell Weaver. He graduated cum laude from the University of Missouri Law School in 1978, where he was a member of the Missouri Law Review. After law school, Professor Weaver was associated with Watson S. Marshall and Ingus in Kansas City, Missouri, and worked for the U.S. Department of Energy's Office of General Counsel in Washington, D.C. Professor Weaver began teaching at the Louis D. Brandeis School of Law in 1982 and holds the rank of Professor of Law and Distinguished University Scholar. He teaches the First Amendment, constitutional law, advanced constitutional law, remedies, administrative law, criminal law, and criminal procedure. He has received the Brandeis School of Law Awards for teaching scholarship and service, and has been awarded the President's Award for outstanding research, scholarship, and creative activity in the field of social science and in the career achievement category. He has also received the President's Award for distinguished service. Professor Weaver is a prolific author who has written dozens of books and articles over the last 25 years. In addition, he has been asked to speak at law schools and conferences around the world and has been visiting professor at law schools in France, England, Germany, Japan, Australia, and Canada. Professor Weaver is particularly noted for his work in the constitutional law area, especially his writings on free speech. Professor Weaver has also served on many community and professional committees. Please welcome Professor Weaver.
Thank you very much for having me here. You know, it's interesting. I did a year-long study looking at the appointments process that I published in the Duke Law Journal last year. And, you know, as this debate has come along, I've heard lots of things said. One being the Constitution requires the Senate to consider this nominee. Well, you know, I got to say, I've read the language a number of times. It doesn't ever say that they have to consider or they have to vote. It says they have to give their advice and consent. And I'll talk more about this in a minute. But the reality is, this idea of an obligation simply isn't in the Constitution. Also, it's not historically accurate. Second, we're told that it's unprecedented that in the history of this country not to consider a president's nominee in the last term. In fact, we have 2 Supreme Court nominees who were rejected and not even considered in the president's final term. So neither one of those things are technically accurate. What I want to do is give you a little bit of history about the advice and consent clause, because I think that helps us understand a bit about what's happening here. When the Constitution was proposed, there was a debate. Should we simply allow the president to make appointments, or should we go in some other direction? the framers chose the advice and consent language. And they did so for good reason, because this was the 18th century. In Europe, we were primarily they had monarchs, and there were serious concerns about separation of powers, about abuse of power, and the American framers decided to adopt Montesquieu's formulation of separation of powers. In other words, the president can nominate, but no one's appointed unless the Senate gives its advice and consent. In other words, and we see that really throughout the Constitution. You know, we have probably one of the most inefficient constitutions in the entire world, and that was intentional on the part of the framers. Now, so they definitely intended to create separation of powers. They definitely intended for both branches to participate in the process. And it's not simply a question of whether somebody's qualified or unqualified. If you look back at the history of the United States, we have 25 nominees who never received an up or down vote in the Senate. We have 11 or 12 nominees who never got out of the Judiciary Committee. Some, there were no hearings whatsoever in terms of those nominees. And if you want to have a sense of what the framers thought, even George Washington had trouble getting Supreme Court nominees confirmed. Actually, for anybody who's interested, there are a couple of very interesting Congressional Research Service studies that look at the nomination process. And one of the things they note is that this has been highly partisan over the years. In other words, when you have a president of one party, you have a Senate controlled by the other party, you often get into disputes about who should be on the court. Now, we've also heard a lot about the idea, well, we have 8 justices, potentially we can have a deadlock. Well, it's important to remember a couple things. One is, the size of the Supreme Court is not mandated in the Constitution. It's at 9 now. It's been at 7. It's actually been evened, 6 justices at one point, 8 justices at another point. In one case, when a justice retired or stepped down in the final year of a term, the Congress simply decided to reduce the size of the Supreme Court rather than to appoint. So it's not clear to me that there is some constitutional obligation on the part of the Senate to consider a particular nominee. I'm not saying they can't. It's fine with me if they do. But I'm not sure there's any constitutional obligation, and certainly historical precedent doesn't suggest that they have to consider the nominee. Now, I would add one other thing, and that is that one of the things we've seen in recent decades is that the Supreme Court is rapidly becoming a policymaker in the United States. And we see that in all sorts of different ways. We see it with, for example, the Obergefell decision on same-sex marriage. Now, I'm not questioning the decision. I'm libertarian. It's fine with me if we have same-sex marriage. But it's clearly policy decision. 5-4 decision of the court. You have, when you look at the founding of the country, there was no recognition of same-sex marriage. When you look at the adoption of the 14th Amendment, there was no recognition of same-sex marriage. So the court's choosing to create policy. Now, it can do that and has done that. We see that also with the Affordable Care Act. And I can give you lots of other examples of the Supreme Court making policy. But if it's going to make policy, it's quite legitimate for the Senate to weigh in terms of saying who they want to have on the court. Bear in mind, once we put people on the court, they're there for life. There are no political checks on what they do. So this is the only point at which the government has significant level of say about who we put on the court. So I think given the fact that the court's increasingly making policy decisions, it's quite appropriate to do what the Senate has historically done, which is to look at their policy positions. And I would add one other thing, and that is that in the last year, we have seen a number of different actions by President Obama involving unilateral action, all based on executive orders. There's significant questions about the constitutionality and legality of those decisions. So it seems to me that it's somewhat appropriate for the Senate to say, look, a number of American people have questions about the legality of these things. We should put the nomination over to the next Senate, to the next president. So, I mean, in other words, my essential point I wanted to make, though, is that, you know, this is not something mandated by the Constitution, and certainly isn't reflected in history. Thank you.
Thank you, Professor Weaver. And next we have Senator Morgan McGarvey. Senator Morgan McGarvey was elected to the Kentucky State Senate in 2012 and represents Louisville's 19th Senatorial District. He doubles as an attorney and his practice focuses on litigation, and he has drawn experience he acquired as a Special Assistant Attorney General in Kentucky and in Washington, D.C. as a staff member for Congressman Ben Chandler. He's an excellent communicator and has sharp sense for understanding the client's needs. Morgan began his career as an associate at the largest law firm in Kentucky. He joined Morgan and Pottinger in 2010 and serves on the firm's marketing committee and is a member of the litigation practice group. Please welcome Senator Morgan McGarvey.
Thank you, Lisa. Thank you all for having me today. I mean that because I know I wasn't the first choice today. I think we have a Democrat elected to the federal delegation from Kentucky, but he's in Washington today. So I think it fell down to me on the state level. I want to address a few things that Professor Weaver said, and then I obviously want to talk some about the legislative side, the political side of how I view this. I want to start off by saying something simply. I'm thrilled to be here today. But I honestly, when I first got the call, thought, how in the world are we going to fill an hour talking about this topic? This is nothing more than a political stunt by the Republican majority to drive their base to the polls in November. That's what this is about. And it's that simple. We can talk about the history, we can talk about the Constitution, we can debate all that. But let's recognize this for exactly what it is. Since we mentioned the history, I do want to talk about it. I actually agree with Professor Weaver. There is nothing in the Constitution that says the Senate must confirm this justice. So how do we look at it then? Well, since it's Justice Scalia's seat, I think we should look at how Justice Scalia would look at it. And he would look at the tradition of what we've done in order to determine the intent of the document. Yes, Professor Weaver is right. There have been Supreme Court nominees who have not gotten a vote. Many of those, however, it was neglected to mention, have been withdrawn by the president himself before they were ever considered for a vote. Most recently, Harriet Miers, as nominated by President Bush, was never given a vote, but President Bush withdrew her before she could get a vote, and then, of course, his eventual nominee did get a confirmation hearing. Also consider this, when we talk about going back to George Washington, the Senate Judiciary Committee was not established until 1816. There was no Senate Judiciary Committee until 1816. It did not get confirmations automatically sent to the Senate Judiciary Committee until 1868. So there weren't automatic confirmation hearings by the Senate Judiciary until 1868. As a matter of fact, there were not open hearings held on Supreme Court justices until 1916 with our very own Louis Brandeis. Open hearings didn't start in full until 1939 when Franklin Delano Roosevelt appointed Felix Frankfurter to the bench. The open hearing was actually in a response to a previous justice, Hugo Black, being confirmed. He was a senator from Alabama, and after he'd been confirmed by the Senate, a journalist actually won a Pulitzer Prize for breaking the story that he'd been a member of the KKK. So people thought it was important to have public hearings then on the nominations. Basically, what I'm telling you is since 1955, every single nominee has received a hearing unless withdrawn by the President of the United States. That's what's at stake here. We're talking about whether they should be confirmed. That's a different topic. Whether they should get a hearing is something we have done. As a matter of fact, the average time from nomination to hearing since 1967 is 50 days. The longest time from nomination to hearing since the advent of public hearings is 82 days, and the longest time from nomination to confirmation is 125 days. If you don't believe me, I'm going to quote you Mitch McConnell's numbers on these confirmations. He said in a July 20th, 2005 floor speech, "Slow walking the process beyond historical norms and engaging in a paper chase simply to delay a timely up or down vote are not the hallmarks of a fair process. The Supreme Court begins its new term on October 3rd. As Senator Frist has pointed out, the average time for a nomination to confirmation for the current justices was 62 days. The average time from nomination to confirmation for President Clinton was 58 days. Justice Ginsburg was confirmed in only 42 days. The Senate has 72 days to complete action on John Roberts' nomination in time for him to join the court by the state of its new term, October 3rd. By any standard, that is a fair goal." That's the history. When a president nominates someone to the Supreme Court, the Senate gives its advice and consent. In order to do that, it must, in fact, hold a hearing. Within hours of a Supreme Court justice's death, to announce that you won't so much as meet with anyone put forward by the President of the United States is wrong. It's a political stunt, and it is not a path we should walk down as a Senate or a country. Now, let me give you my views on this. My views are simple. To the victor goes the spoils. That's how I view it in the legislature. In the state Senate, we too have to confirm people. As a matter of fact, we have confirmations coming up on Friday in our last day of the regular session. We have administrative law judges. We have very important positions to boards and commissions throughout the state of Kentucky put forward by Governor Bevin, a governor of a different party than myself. Should I stand up on the Senate floor and filibuster on the last day because Governor Bevin only got 16% of the total vote of the number of people living in Kentucky? No, he's the governor. It's his job to put these forward these people for nomination. It is our job to confirm them if they are qualified, not whether I agree with them on every single thing they believe, but whether they are qualified. Ironically enough, Senator McConnell agrees with me in that approach. He said in a June 26, 2001 Judiciary Committee hearing, "My view then and my view now is that the president won the election, no matter what the margin, and is entitled for the most part to tilt the judiciary in the direction he feels appropriate." He added that the appropriate role of the Senate is largely to judge the competence and the integrity and the fitness of a judge to be on the bench. They don't have to confirm Merrick Garland, although what Richard Dawahare said is exactly correct. He's been praised before. They don't have to confirm them. To not even so much as have a hearing goes against the precedent of what we do as a country, and I think sets a dangerous precedent going forward. At what point is it too arbitrary? When there's 2 years left in a president's term, 3 years? At what point does the Senate just say, we take the whole thing over? They need to have this confirmation hearing.
Thank you, Senator McGarvey. I'd like to make mention that on your tables you have questionnaire cards. If you'd like to fill out questions, we have two board members, Dale Josie and Tom Vander Rostein, that will be walking the room to collect your questions. Our next speaker is Andrew Condia. Andrew graduated from Bellarmine University with a BA in History. He has worked for Senator Mitch McConnell since January 2014. As Senator McConnell's field representative, he serves as his eyes and ears and as a spokesperson, not only in Jefferson County, but in 15 surrounding counties and Fort Knox. Today, Andrew is here to represent the senator. Please welcome Andrew Condia.
Well, thank you very much. As you gathered from my bio, I'm not an attorney, so I'm not going to have any sort of legal argument for you today. So hopefully you like the salad or you're going to be disappointed. But what I can provide is some Senate background and also some political reasons for why Senator McConnell has arrived at the decision that he has. Let me start by saying this is about the process, not about the nominee, although Judge Garland is not a moderate by any stretch of the imagination. To confirm a justice in an election year would be opposite of everything the Senate has stood for since its inception. The last time it happened was in 1888 during President Grover Cleveland's administration. Now you all remember those days, the Cleveland administration, great times. And before you say 1988, it's very different, finishing up work that was held over in 1987, as was the case with Justice Anthony Kennedy in very early 1988, and this was after the Senate rejected Robert Bork. People also say, well, there was an election in 2012, and President Obama won overwhelmingly, and the American people have already spoken, and President Obama did win re-election overwhelmingly. Well, there was an election in 2014 that many people seem to forget. And the House was kept overwhelmingly Republican, and Republicans recaptured the Senate for the first time since 2006. I don't think the American people did that with the idea that President Obama would get whatever he wanted. The American people are getting what they voted for in 2014. Now, there's also the argument that President Obama has done his job. Now the Senate needs to do theirs. Well, the Senate's doing the job it was elected to do in 2014, and that is to serve as a check on President Obama and the executive branch. If the American people want the Senate to change the ideological tilt of the court for an entire generation, then I can only imagine we will see a President Clinton or a President Sanders in January 2017, and perhaps a Democratic Senate. But the Senate has no requirement to be a rubber stamp for the president. You know how I know that? Because many Democratic senators said so. Senator Chuck Schumer said to become the Democratic leader. The idea that it's my way or no way is not going to work. Furthermore, I would argue to my colleagues, it is not what the Founding Fathers wanted. 1 out of every 5 Supreme Court nominees did not make it to the Supreme Court. That is part of the tradition of this country. Vice President Biden, then Senator Biden. It is difficult to imagine that after 4 attempts to exclude the president from the selection process at the Constitutional Convention, the framers intended anything less than the broadest role for the Senate in choosing the court and checking the president in every way. Senator Patrick Leahy, the ranking member of the Judiciary Committee, then the chairman of the Judiciary Committee. The Constitution, as we know, gives the Senate a central role in the confirmation of a Supreme Court justice. Nothing in our makeup, nothing in the history of this country assumes that the Senate would be a rubber stamp for the president's nominees. After all, it was the Senate that turned down some nominees of George Washington because it would not be a rubber stamp. And finally, and my personal favorite, Senator Harry Reid. The duties of the United States Senate are set forth in the Constitution of the United States. Nowhere in that document does it say the Senate has a duty to give presidential nominees a vote. I want to respond to something that Senator McGarvey said as well. Senator McConnell hasn't said that there won't be confirmation hearings. Senator Grassley is the chairman of the Judiciary Committee. He's 82 years old. He's a big boy. He can be independent and make decisions that he wants. If that's Senator Grassley's decision, that's Senator Grassley's decision. Senator McConnell has given committee chairmen the ability to have more independence and free reign, which is very unlike the Senate in recent years. So I wanted to respond to that as well. But to close, the Washington Post fact checker gave the statement that the Senate has a constitutional responsibility to consider a Supreme Court nomination 3 Pinocchios, saying that the Democrats are telling a convenient fairy tale. Now, the Senate's going to continue to work in a bipartisan fashion with President Obama in areas where there is widespread agreement. A 5-year transportation bill, first one since the 90s, rewrite of No Child Left Behind, and the Comprehensive Addiction and Recovery Act to fight the heroin epidemic in Kentucky and across the country are just 3 examples. But there's no agreement on confirming a Supreme Court justice in election year. And in short, it will not happen. Thank you very much.
Thank you, Andrew. And now we will move to the question portion of our program. Tom?
Thank you. This question is for any member of the panel who wishes to respond. One of our guests asked, on the flip side of the coin, could a president decide to wait to nominate a Supreme Court justice for up to a year before a midterm election so the voters could decide on 1/3 of the U.S. Senate to advise and consent? And if yes, couldn't this dynamic lead to long-term vacancies on the Supreme Court?
I'm sorry, could you repeat that?
The question was, could a president decide to wait to nominate someone to the Supreme Court, awaiting a midterm election, because 1/3 of the senators are elected each 2 years. Could a president wait a year or more to nominate someone to wait for a Senate that's more favorable to their advise and consent role?
I mean, if they would like, I think more or less that's what you're going to see right now. A third of the Senate is also up for confirmation right here, or excuse me, up for re-election here in 2016. So they'll have a chance to weigh in on that and on the president.
I would say, I would add, no, the president cannot. And for the simple reason, the same reason why the Constitution does demand that the Senate act on this nominee, and that is precedence. The history of this nation is that they have always confirmed in the last year the president's term, except 1844, and it was an independent president. He didn't get anything passed for 4 years. The history behind that is Tyler was he joined the Whig Party to get elected and then quickly became an independent. He had nobody on his side. So throw that out. There's no case where they didn't refuse the act. 5 times in the last century, they did approve. The Senate did approve the nominee. Justice Anthony Kennedy, 97-0, a Democratic-controlled Senate, 97-0. Can you imagine that? So the answer is no, and it hasn't happened. A president doesn't wait a year to do that. So the answer would be no. I guess technically under the Constitution they could, but because precedents, it's never happened before, it's not the right thing to do, I would say no. The president cannot do that.
Senator McGarvey?
Yeah, and although the Constitution doesn't provide a timeline, it does say he shall nominate judges. So the shall, of course, in the legal means that the president must, in fact, do that. I want to address, one thing we've talked about, how it's important for the American people's voice to be heard in this process, and it's important for them to let them decide. When you talk about midterm elections, again, you talk about the Senate, it's only a third of the Senate that's up every year. I think that's important to recognize. Like, for instance, when we say the American people voted to change the United States Senate, no, a third of the senators up, and I think 7 of the seats taken back were taken by states that Mitt Romney won. So the 5 million more people that voted for President Obama in 2012 actually had no voice in this process. I think that it's important to keep in mind that we've nominated 6 justices since I think 1908 in election years, and it's something we need to continue doing and shouldn't hold out for a midterm election for 1/3 of the United States Senate.
Excuse me. I think the Constitution's clear that the president's required to nominate, but you're entirely correct. It doesn't say how soon. So, I mean, that's an open question, I think. I do disagree on the precedent, but I've already said that before, that there have been 2 Supreme Court nominees in the last term that were never confirmed. The other thing I'd mention is this question that keeps coming up about whether President Obama was overwhelmingly elected. There was an electoral landslide. Popular vote was 52-53%. So it wasn't a popular vote landslide by any means.
Okay, Dale?
Yes, our next question comes from one of our students, and we're really grateful to the William E. Barth Foundation that we have 2 schools present this morning. But the student has a question for Senator McGarvey as follows. Regarding the qualifications of a Supreme Court nominee, what would be a key factor, in your opinion, for nominating a Supreme Court justice?
That's a great question. I appreciate the students being here today. I think you have to look at a track record when you're looking at a Supreme Court justice. You have to see, one, that they have the intellectual ability to do the job. Whether you agree with someone on an ideological basis really, to me, isn't as important as can they do the job. This is something, the Supreme Court of the United States is a wonderful institution, and we want our best and brightest people. Notice I didn't say lawyers, but we do want our best and brightest people on the Supreme Court. You don't actually have to be a lawyer to be a Supreme Court justice. That's something you don't have to do. We have a tradition of putting lawyers on there for obvious reasons. That is where a lot of people get their training to be Supreme Court justice. So one, are they smart enough to do the job? 2, in their track record, I think it's important, since we've had the open confirmation hearings, to get an idea, and not so much of, do you like college football? Do you like college basketball? Are you a Wildcat or a Cardinals fan? But really your judicial philosophy. I think there was a great quote in an article I read that, these legal questions are too complex a lot of times that come before the Supreme Court just to say they're defined by one statute or one document or one thing. What is someone's judicial philosophy? Do they believe in judicial restraint? Do they believe in judicial activism? Where are they going to take the court? As Professor Weaver said, this is a lifetime appointment. I think knowing someone's judicial philosophy and how they view how the law should be interpreted is good. And the next thing I would want to see someone that has at least the ability to have an open mind when confronting a question. So that they have a core set of values, they have a judicial philosophy, but when they get a case, they review that case on the merits and then take those merits and are able to extrapolate out the effect going forward.
The next question is for Professor Weaver. One of our guests asked, if the Senate does not act on Obama's nomination within a reasonable time, have they waived the right to consent? And if such a waiver could occur, when would it occur? 6 months, 1 year, 5 years, et cetera?
Actually, I don't find a waiver provision in the Constitution. And in the past, in terms of precedent, in the 2 instances where they chose not to confirm in the final year, it was simply passed to the next president who made the nomination and confirmed the justice.
Next question is for all the panelists to respond. The question is as follows: not only is this Supreme Court nominee put on hold, there are also about 184 appellate court nominees also on hold for the same reason, that the Supreme Court nominee is not heard. How are we going to get politics out of the judicial process, or is that possible?
It's a great question. And it's part of the fundamental problem we're seeing here, in that we have a nation that's very divided. We see that in the elections. We also see it in the judiciary right now. I mean, you have people saying, well, we should interpret, as Scalia argued, that we should interpret the Constitution according to the intent of the framers. We have other people saying, no, 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 this is a living Constitution. And I always ask when they say that, what does that mean? And typically what it means is, well, we can create new rights. And my question on that is, well, where do these rights come from? How do we decide whether they exist? If it's just a popular vote, well, then it's just democracy. It's not really the Constitution. And when you have these divisions where we're arguing about whether it's the framers' intent or whether it's a living Constitution, and that's part of what the fight about the judiciary is about, then it seems to me what they're reflecting are broader debates within society about the role of, where society should go. And if the court's going to weigh in on those things and be a policymaker, then I think by definition they're becoming more political, and you can expect the politicians to want to weigh in on that issue.
Just as a follow-up question, when you read the media reports, the Republican Party seems to be interpreted or positioned as the party of no from day one of President Obama's election. So the process becomes, how do you remove how do you move the process forward without seeing it's any kind of a personal engagement, but it is indeed about the process and not about the presidency?
It requires both parties to cooperate, and I'm not sure how you get there. Maybe that's his question.
Well, I would say that, yes, there is not cooperation on some things, but there has also been a fair amount of bipartisan cooperation on a lot of things just since 2014 on a number of issues that I commented on. So, yes, it's all a slow and painful process, but that's how it works. Unfortunately, Congress, the legislative branch, serves as a check. It's not the express checkout line at the grocery store. It takes time, and sometimes, it looks slow and like things aren't happening, but I can tell you there's been a fair amount of bipartisan accomplishment. Some folks don't want to talk about it, and that's, this is a major issue, and yes, it's a disagreement, and there's some nominations that are like that as well, but I think there's been a fair amount of bipartisan cooperation, but I'm biased.
Well, if I can add to that a little bit, one thing I'll say about this that we talk about, and I was talking about with one of my my colleagues on the walk over here today, nobody comes into this with completely clean hands. There are both Democrats and Republicans who have been guilty of this in the past. I think the point in what I hear all the time and what I feel is right now I almost don't care who started it. Let's move forward a little bit past this. And while there have been bipartisan agreements on certain things, I think when we talk about this issue in particular, what I find disturbing is that we haven't even had the hearings. We haven't had the hearings to find out what those judicial philosophies are. Yes, government isn't an express lane, like Andrew said, and I agree with him on that. I mean, you think about it, think where you are right now, and think, oh, I want things to move faster. There's somebody else who feels differently than you about that issue that wants it held up. Democracy is held together oftentimes by the tension of these competing ideas, and that we move forward together, and that togetherness sometimes leads in a slower result. But what we're seeing right now is kind of obstructionism on an unprecedented level. And that is, we're not even getting the debate out in the public on these judges. And I think that's what's ultimately harmful in the long term.
I totally agree with that, Senator. As you said, that 140 appellate vacancies right now or something like that. And unfortunately, I believe this is a case. I believe that Republicans have been far more hesitant to fill these federal judicial vacancies than the Democrats. I don't know about that, but I do know for a fact that they've been leaving these vacancies open a long time. And that undercuts their argument, this is Obama's last year in office. They just are obstructing. From day one, they have tried to deny President Obama's legitimacy to act as president, to be as president. I mean, this is unprecedented too. Before he even took his seat, he was elected. The goal of the Republican Party was not to help America overcome the greatest financial collapse since the Great Depression, was not to help struggling American families, but was to make President Obama a one-term president. I mean, it's a dagger in the heart of our democracy. And this is just part and parcel, this refusal to even consider this nominee a fine nominee. And I agree with, let's forget the past, let's go forward. I want to sing Senator McConnell's praises and the Republicans. I really do, because if they win, we win. There's always a price to pay. Just because the Constitution doesn't have a penalty to the Senate for not acting like they should, doesn't mean there's not a price to pay. There is. And in this case, the price is our unity, our nation, our institutions, and our ability to be a world leader in the values that we've had for 200 years. So there is a price to pay. And I want them to be leaders. It's in their hands. They can do this and other things to bring the country together. It is in their hands right now. And I hope they take a positive, because I want them to win, because they win, we win. Confirming Garland is affirming the American way, and I really hope they do it.
This question is for any or all members of the panel. If there is another legal dispute over the presidential election and there's only 8 justices with a 4-to-4 split on the Supreme Court, will it be a state Supreme Court that ultimately decides who will be our next president?
That's a great question, and let me effectively kill that for the whole panel. I would be absolutely stunned if this is a close election. Personal opinion. And that's all I have to say about that.
But the answer to the question is yes. I mean, if you look back at the Bush v. Gore decision, and of course, I don't think we thought it was going to be that close then, but all of a sudden, the Florida State Supreme Court said the recount should continue, and the Supreme Court said no, and George Bush was sworn in as President of the United States. So, as it would stand right now, the Florida Supreme Court's decision would have stood, the recount would have continued, and depending on which news sources you pay attention to or what's on your Facebook feed, you might argue about who would have been president that year. But I mean, I think the other instances, there's a case right now. Take something less drastic, right? Where we are right now with these 4-4 decisions, there's a case, Hawkins v. Community Bank of Raymore. It's a perfect example. It's a boring case for probably, I'm going to say 99%. There are 2 lawyers from my firm here today, so maybe 98% of the people in this firm, in this room. It's a boring case. The case is not a hot button issue case, right? It's about spousal guarantors and the rights that they have and the rights that they have under the Equal Credit Opportunity Act. Well, the Sixth Circuit says one thing, the Eighth Circuit says another. Two totally different, two completely different interpretations. Went up to the Supreme Court recently, it came down 4-4. That means the Eighth Circuit is upheld. That means the Sixth Circuit is still in place. And so you have a split decision in the circuits. There is no certainty to this law in the country. That's what the Supreme Court provides, is that certainty, that final say-so. With a 4-4 decision, whether it's over who's the President of the United States, over who is covered under the Equal Credit Opportunity Act, it's still important to a lot of people.
Okay, I think we have time for one more question.
Very good. This question will be for Andrew on the end of the table. In terms of the Republican position, how did the party determine that the current nominee put forward by President Obama, is not moderate?
Well, I can't speak for the entire Republican Party. I can speak from Senator McConnell's perspective, and that was from Senator McConnell voted against his confirmation in 1997 to be on the D.C. Circuit. And this is a gentleman that has, in the senator's opinion, long been very liberal justice. He once wrote a ruling that wanted to outlaw Mother's Day. Now, this is a random example, but I'm just pointing out that, but the senator knows Judge Garland's record, and that's how he arrived at that decision. But I can't speak for other members of the caucus or the Republican Party as a whole. So.
All right, well, thank you. And on behalf of the entire Louisville Forum, we thank you for being with us today. As an expression of our appreciation, we have our Louisville Forum mint julep cups that we will give out to each of the speakers today. And we also want to again express our appreciation to the trustees of the William E. Barth Foundation for the grant that makes it possible for students and administrators from Jefferson County Public Schools to attend our monthly meetings throughout the school year. Our next meeting will be held on Wednesday, May 11th. Reservations may be made online at louisvilleforum.org or by calling our voicemail at 329-0111. Thank you and have a great day.